Ms Holstead,
Kia ora.
kia ora. In the session this morning, at which I was unfortunately unable to be present, I understand that you spoke to the systems role that the Ministry has under the current regulatory regime, and that that really you described the role as shaping the system. Is that right?
That's
right?
what we've described as the purpose of the Ministry, yes.
So you're creating the regulatory framework and you're the lead advisor. One of the statements that you've set out in your witness statement, and I'll just read it out into the record, and it won't be foreign to you because it's your language. You've said, we all have a responsibility to all children to do everything we can to eliminate the risk of harm to children in the education system and to provide a safe environment. In terms of that work of, it's everyone's task to minimise that risk of harm, am I right that you need to know quite a bit about what's happening in the system, about where harm is occurring and the nature and extent of that harm?
And to the extent possible, and to have some understanding of where it may occur, to the extent that that is possible.
And with that understanding, it then becomes more possible, doesn't it, to calibrate the response to the size of the problem and the nature of the problem of abuse in education settings?
Possibly, it depends on the availability of resources always, but yes, within the resources available, one can allocate them accordingly.
But as the lead advisor, if you had that information and you could see that there was a problem in a particular element of the system, you would be advising the minister, and it's the ministerial governmental prioritisation of resources to fix that problem.
Well, I could give that advice, yes. That advice may or may not be taken.
Quite.
Yes.
Bit like being a lawyer. But you also say that schools are not required to advise the ministry if they've received, I think the language you've used in your statement is a sensitive claim. So does that mean that if a school's receiving a report of abuse, if we use that language, they're not actually required under the current framework to notify the ministry of that?
I think that's right. I believe that's the case, yes.
And so when we think about the 1989 reforms, the Tomorrow's Schools regime, which we're effectively still under now, in education settings, there might be reports of abuse made directly to the Teaching Council under the current regime.
Correct.
It might be made to the school itself, is that right?
Yes, to the board.
It might be made to the Education Review Office in the context of their processes with a school.
Yes.
There might also be a report to the police.
Yes.
Potentially of which the school has no knowledge.
Correct.
And in relation to the faith-based schools, there might be a report of that abuse only to the particular faith.
Well, to the proprietor, you mean?
Leaving aside the sort of the language, effectively it becomes within the knowledge of the faith entity and not the school, potentially.
That's the proprietor, yeah.
So we've got multiple actors in the system.
Correct.
And multiple points of entry of reports of abuse. Thinking about the regime that would have applied before the 1989 Tomorrow's Schools reforms, would there have been fewer points of entry for reports of abuse?
Yes, I think there would have been. Yeah, I think that's probably right, because we didn't have the boards. We wouldn't have had proprietors separate from the what were essentially private schools, the faith-based schools, and back in the day, 1950, were private schools. But you still could have the possibility of the department not knowing.
And we saw that, didn't we, with the Marylands, that there were
right.
some reports of abuse directly to the order running that school,
That's right.
that potentially the department, as it was at the time,
That's right.
may have had no knowledge.
Large numbers, actually,
Yeah.
relative to the occurrence, yes.
But in terms of evaluative term, assessing the current regime of multiple points of entry, and as you say with boards, there's thousands of them.
2,500,
Yeah.
yes.
Was the system simpler before 1989 in terms of if somebody had wanted to set up a system to capture all of the reports of abuse, would it have been less potential entry points?
I think potentially, yes. So I haven't done that assessment, but I think my intuition says that would be right.
We've seen reference in some of the documents relating to Maryland, and I'm not taking you to them, to back in the days when it was Department of Education pre-1989, to there being a child welfare division within the Department of Education. And it seemed that potentially there was a closer alignment of child welfare considerations with education back in that dynamic that operated some decades ago now. Is there the child welfare element now? So first of all, just in terms of the past, and you may not know, might be one of those topics that we follow up with you after the hearing, but there clearly was a child welfare division within the Department of Education in those early part of the 50s, certainly. In the current regime, is that sort of, do you think there's a separation of the interests of the child welfare from education across to other agencies that potentially leaves a gap?
There's two different things that exist now, and one of which I did refer to this morning and isn't in my notes. So the first of those is a recently announced agreement with Oranga Tamariki and their action plan and the role that education, health and social development have committed to working with that institution regarding, in time, giving priority access to learning support, for example, and other supports in the system to children in care. The second thing that, of course, is that we've got legislation which talks about the need for our schools to provide safe and inclusive schools. We have a national education learning priorities framework which reinforces that. And then we have staff in Te Maho, that the front porch of the ministry, working directly with schools. So there's still a network of people concerned about child welfare in the broader sense, as well as those who are specifically in care.
So just coming back to the current position with the multiple entry points of reports of abuse, I'm curious about the fact that the system the ministry is steward of doesn't accommodate a central collation point of all of that information. I'm right there, aren't I, that the ministry doesn't have a central data set of where abuse has occurred in educational settings in the past or today?
Well, I think in terms of the past, I think this commission has revealed a lot of that. But in terms of today, there's a couple of things about complaints. One of the things that has changed in the world since 1989 is social media. So complaints don't come through any one channel ever anymore. So even if institutions establish themselves as having single points of entry, people will make complaints in any number of spheres.
That's right. Yeah,
And sometimes they're defensible and sometimes they're not. So what we aim to do is use different points of data to give us an indication of the health of the system. And one of the things that we're engaged with ministers at the moment is identifying what measures we will use to judge the well-being of children in the system. So it's a live issue, to your point.
So in order to, so leaving aside the point that you might have, there's clearly multiple points of entry, and as you say, more emerging every day with technology. That's not really my point. My point is around the ministry at the centre of the hub and as the lead advisor, actually having a system and a mechanism by which you actually know what is happening in terms of abuse in education settings.
So it goes to the point I was making, that it's not, we don't have to collate it, but we have to access it. So that's my point, is that what we need to be doing, and we're working to describe with ministers, is what are the measures. So there's a child and wellbeing strategy against which we are required to report to the government regularly. That was originally led out of the Department of Prime Minister and Cabinet, and it's a document that is overseen by joint chief executives of health, education, social welfare, justice, police. So within that framework, we are required to report on a number of measures. We're determining what are the measures that will give us information about wellbeing, which will need to include issues of abuse.
So that's in a forward-looking sense.
Yes, but not forward-looking in terms of a decade, forward-looking in terms of months, not years.
So over a period of time, 2, 3, 5, 10 years, it might reveal some patterns that in terms of which kinds of schools, whether it's private schools or state integrated schools or state schools or special schools, at which there might be greater levels of abuse.
I would say that
abuse as defined in our terms of reference.
I would say that we have got a pretty good idea now in terms of the abuse in care over time. And this a little bit goes to the question, the issue that was raised before lunch about, are we better off with a centralised system or a decentralised system, and what are the risks and opportunities of that? Because ironically, while we had a more centralised system back in the day, we also had very high, relatively high levels of abuse, and they were, in the first instance, in private schools.